No, okay. So this is the stream for where Sean just basically goes over the arrests. It's going over basically the pictures that I've already showed you guys. He did not have the arrest affidavit yet. But we're gonna just jump forward into this was the whole stream that he did the next day when we had the arraignment and everything else. So this took a full day and kind of sat and just ruminated and did nothing. So we're gonna watch this next.
So while we're waiting, as I
This is the the arraignment heard around the world where Nick, April, and Kayla get arraigned the following full day. So they're arrested at 11 o'clock. Everyone knows they're arrested. Not much goes on for the rest of that day. The following day is the Friday before Memorial Day weekend. And that's when we have the arraignment. The arraignment is basically where you're going to hear about bond being set, bond conditions being set, which I have all that stuff and I can show you, and you guys can see a little bit more about how that actually looks on paper. But we'll go through the video first because it's not going to be the full 30 minutes. We're just going to jump forward to when Nick actually gets arraigned. And then honestly, we might jump forward to April's arraignment, or not April's arraignment, Kayla's arraignment.
these criminal circumstances are frankly the least of my concerns. I mean, whatever, I think he'll have a reasonable outcome here unless he really screws that up. But I'm thinking about the rest of his life.
Well, that's true. He again, this is an opportunity for him. We've seen him on the streams. There's been rumors of drug problems. It seemed to be somewhat more credible now, right? And so this is an opportunity for him to. When I say play the system, you're not playing the system. You're taking advantage of the system, right? If you use this as an opportunity to get clean, he can come. Really this could
be general rules. General rules.
What's that?
It's like the way how Nick Rakieta is sitting, how he's tilted. That's also like, another symptom of like drug use is it fucks up your equilibrium.
Oh yeah. Yep. And then anytime I've used coke, and I've had varying qualities of cocaine and stuff that I've used personally.
The part is like whichever part of your body is like your predominant ends up being, a bit heavier, so you have to offset it in order to feel balanced.
Which would make sense. Predominantly, most people are right-handed, and he's leaning a bit to his left there, so that would make sense.
Yeah, so that's like an obvious tell that he has something fucked up with him.
Yeah, I would say I know that I can only imagine drinking as much as he drank. On top of every time I've done coke, you have the equivalent of like one of the worst hangover headaches ever, like the next day. Like when you get into using like pretty regularly, oh my God, you will have fucking headaches like no tomorrow. So, and it's like migraine level pain. So I can imagine he's got the hangover on top of the migraine from his coke use on top of knowing what he's about to deal with people. It's all compounding right now.
Rules of practice prohibit any recording other than the official record of the judicial branch, which is recorded by a certified court reporter. I imagine that transcripts can be available. That's under General Rule of Practice 42 or 4.02, Subdivision 5 at Prin 5. I need to tell everyone that a violation of that rule could lead to contempt proceedings. We are on the record in 34 CR 24.
For the record, I have an email.
And Madam Clerk, if you can disable that the buzzing or bell noise each time someone joins this court.
Yeah, I just thought of something funny.
Yep.
Since Belinda hates me like hating on the powdered donut shit that people have been using as an excuse. 26 grams of cocaine or whatever the fuck Nick Rakieta had was enough to cover a baker's dozen, right?
Yeah.
To give it a good light powdering, and then you put the powdered sugar on top of that to mask it.
or it's the equivalent of what you get on one funnel cake at a state fair.
Yeah.
But all right, I'm gonna play this. I think we're forward enough in time. I don't care if we hear that. If anything, just to let everybody know, there's a portion here where somebody jumps in and tells Nick to kill himself. It might have been a better option for Nick at this point, but I don't care if that plays out. I'm just trying to get past all the legal bleh bullshit.
I mean, seppuku. I mean, he makes jokes about the East. He might as well take the lead.
Yeah.
Yes, sir.
Okay. Count one is second-degree possession, 25 grams or more of cocaine or methamphetamine. This is in violation of Minnesota Statute 152.022, subdivision 2, print A, print 1. The maximum sentence for that count is 25 years in prison and/or a $500,000 fine. Count two is possession of ammunition or any firearm with the user of controlled substances. This is a gross misdemeanor, so the maximum sentence is 364 days in the Kansas County Jail and/or a $3,000 fine. Count three, endangerment of a child when presence with a sale or possession of a controlled substance. Again, a gross misdemeanor. Maximum.
Do all your coke out, Nick, and kill yourself, you stupid motherfucker.
You know what? I'm glad I was able to get that.
It's like, Nick heard that because everyone else did.
Oh, it's just his deflated like facial expression, like right when it happens.
164 days in the Kansas County Jail and/or a $3,000 fine. Count three, endangerment of a child when presence with a sale or possession of a controlled substance. Again, a gross misdemeanor. Maximum.
Do all your coke out, Nick, and kill yourself, you stupid motherfucker.
I'm gonna warn
that reaction, he's just like breathing it in. And going,
this is my life,
man.
now.
What the fuck?
That is my audience. This is my life.
Everyone, again, this is a court proceeding. If you
whatever, blah blah blah.
Cornahachi, no one needs to at this point. Lastly, I think I was saying that the count three gross misdemeanor has a maximum sentence of 364 days and/or a $3,000 fine. Mr. Rakieta, you understand what you've been charged with? And second question, the maximum sentences associated with each count?
Yes, Your Honor.
All right. Now, I don't mean to insult your intelligence, given you are an attorney, but it's important that I know that you understand your rights here. First of all, you are presumed to be not guilty of these charges. It is the state, not you, that has to prove what has been.
There's basically a lot of legal jargon here for he is hearing all his options.
Or cross-examine anyone who testifies against your interest. You have a right to call witnesses and the power of subpoena. You have a right to all of the state's discovery before trial. And this is a Rule 5.
Cred.
What's that?
Whoever is like running the stream pulled that comment up, and it's from this Iris loves something.
Oh, that. Nick's like, a really thorough lawyer, okay? He wanted to see from the inside out on how the system operates for felons. There's no content going on right now. I will become the content, damn it.
I mean, he's a lawyer. He could practically go into any jail cell he wants to, potentially represent a client.
Yeah. There was easier ways to do this. Trust me. I don't think he thought of that.
5 hearing. Sometimes we call it a bail hearing. We'll set this for a Rule 8 hearing. Under the rules, you have right to have that hearing within 14 days of today's hearing, but you could waive that as well, given your right to seek counsel if you so choose. Do you want this scheduled within 14 days, a Rule 8?
No, Your Honor, I'd like to waive that. We can combine it into a contested omnibus hearing. That would work.
All right, so we could, for today's purposes, combine Rule 5, Rule 8?
Yes, sir.
All right.
So basically, he makes this a contested omnibus hearing, which all that means is that he's saying that he's contesting the charges put against him, that he plans on fighting this to some extent. They're going to have to go further in the legal process, and that he's just ready to hear his bail terms and stuff like that. That's honestly all it means.
All right. And before you ask for a speedy, you want to hear what the state is requesting as far as release conditions?
Yes, I'd like to hear what the state is requesting.
I didn't say it, but you also have the right to have me read the complaint today.
No, I'll waive it, right, sir.
All right, very well. Mr. Kornhachi, what is the state requesting as far as release conditions?
Yes, Your Honor. The state is requesting $50,000 unconditional. In the alternative, we would agree to RPR with standard drug conditions, which would include no use, random testing, no use and possession of firearms, contact probation as directed, don't leave the state without permission from the court, remain law-abiding, keep in contact with probation, and other standard conditions.
Mr. Rakieta, any objection to those conditions?
I object to the $50,000 bail. I think it's unduly burdensome and in violation of the Eighth Amendment.
All right, what about the conditions?
Release conditions sound fine.
All right, the court will set unconditionally amount of $50,000, cash or bond. Conditionally, you'll be released on your own personal recognizance. In all instances, you need to be law-abiding and show up for all your court appearances. Conditions are as follows: abstain from the use of alcohol or any mood-altering chemicals not prescribed by your physician. That will be subject to random testing. So the court will order that you meet with probation upon your release, sign their agreement, and cooperate fully. You're not to possess any weapons, firearms of any nature, or be in the presence of anyone with a firearm or dangerous weapon. And do not leave the state of Minnesota without prior approval of the court. Any questions about those release conditions?
Yes, Your Honor. Did you say 50 or 15,000?
50000. 50.
Thank you, Your Honor.
Okay, let me ask this. Do you still want a speedy omnibus, or can it be scheduled in normal course?
You rescheduled in normal course, Your Honor.
Very well. Madam Clerk, do we have a date for that?
Which, by the way, isn't one of the things that Barnes is fighting is saying for a Sixth Amendment? Isn't his right to a speedy trial?
I thought that was under the Eighth Amendment because it's tied in with undue, or not undue, but
right to a public trial without unnecessary delay. Yeah, no, Sixth is speedy trial.
Okay, so what was the Eighth Amendment? Because I'm thinking that's like torture or something it has to deal with, right?
Yeah, that might be excessive bail. Yep.
Okay. So fucking Barnes like $50,000. That's an Eighth Amendment violation.
Yeah, I think they're saying it's excessive bail because of his first time offender status. And then seventh is
I mean, there was a guy near where I lived who was arrested and he had a $50K bail.
Okay.
It's like it's nothing excessive. In fact, in small counties that's like one of the beginning bails that you get. Outside of like maybe outside of like 20 if you're in a smaller jurisdiction, but like in big counties like where I'm at, 50K is like the minimum.
Inflation, man. It's a hell of a thing.
Well, I mean, with inflation, it's going to probably go higher. Wait, maybe that's how we can get rid of inflation. It's an Eighth Amendment violation.
But just for chat, if you guys want, so this is the actual release agreement that you basically just heard the judge go over. It's just saying that he does have to appear in court for his next appearance. That he shall keep in contact or hire an attorney on his own. Defendant shall report any changes of addresses. I blurred all that out because I didn't know how much of the court information was public.
Hold on one second. Belinda brings up the point why it is like the minimum for 50,000. It's because of the firearms. Like everyone. Like if you live in a rural area, you're going to have people who have firearms. So that is like, not a mandatory minimum, but just like, a minimum that is like over a lot of cases.
Well, that's why they have the or thing here. So it's he has to either pay the money, so he has the option to pay the money through bail bond or whatever means, and keep his firearms. That way the state's not infringing upon his Second Amendment right to bear arms, or he can surrender his firearms, which he would have to do. Right here is the checkbox for that, and have to follow all of these other stipulations in order to not pay the money. So it's basically a either or process. And I've heard a lot of people say that, oh, only Minnesota's like this. I believe a lot of more
I mean, it
rural
is like that
states.
where I live.
Yeah, I don't know the processes for Iowa to tell you, but I know, yeah, basically he had the option to, he could do a bail bond, or he could pay $50,000. He's allowed to drink. He's allowed to use drugs. He wouldn't be in violation of his bond. He would be able to retain his firearms. They could then charge additional charges on him. He's not free from gaining additional charges, but he would be free to at least consume alcohol legally. Where when he actually did this release, he followed the conditional release initially, and then I'll show you proof a week later where he decided to then go and contact a bail bond, at least for him. I don't know if his wife's under different counsel now or whatever, but he ended up going to a bail bond and petitioning and getting the $50,000 to then pay his full bond to then have the unconditioned release. So he actually changed from a conditional release to an unconditional release by paying a bail bond, or by gaining a bail bond and then paying the bond for that. But yeah, this is all the stuff he agreed to. So release on his or her personal recognizance, shall not leave the state of Minnesota, shall not possess or consume alcoholic beverages, and obviously there's even further mandates to that. Ironically, he did not have to commit to testing, which is one thing I noticed on this. He did have to contact probation.
Yeah. To answer Belinda, basically it doesn't matter if kids are or are not involved, because he wasn't charged with the child neglect when he was first arrested. It was for the cocaine and firearm shit, correct?
So
the child neglect came afterwards.
I believe the child neglect was a portion for, and I've got the full police report, and kind of when you look at the affidavit, I believe they were starting to incorporate the child neglect early. So if you go back and you look at the affidavit, the Rakieta warrant affidavit.
Because I mean, just for drugs and cocaine, like, yeah, if this is a first time offense and they have they have guns involved, like, period, yeah, the 50,000 would be a normal bail. Because and the way how bail, yeah, the way how bail works, it's just like a tenth that you have to pay, and then after your trial, if like whether you win or lose, I think you still have to like pay the full amount. Correct?
Restate that. Sorry.
After you win or lose the case, like you still have to pay that full amount of bail, or the bail becomes null and void if you win.
Back, basically. So he paid $10,000, or for $50,000, he would have had to pay 10%, which would have been $5,000. If he had paid $50,000 cash to the court, he would only get $45,000 back, win or lose, as long as he proceeds with the trial.
And that's mainly just, isn't that just to cover like the expense or the expenses that the state had to go through by getting the cops involved for vehicles and shit?
Yep. Yeah. It's a rough estimate to cover the expense of your arrest and warrant and time and everything that went into this.
Yeah, and given how how standardized most police forces are becoming now, that's another reason why the bond would be around 50,000, I think.
And yeah, just to show that even in the affidavit that the detective applied for. However, as recent years have, the show has been on social media, entertainment show, strictly online based. It was reported that the Imholtes may have been staying with the Rakietas, and the home was in disarray and cluttered. It was reported from the church preschool teacher that the children had complained, and back to top of page, of being hungry, not being fed, wearing the same clothes for 3 to 4 days at a time, and would start to smell. So this is just showing that even with the affidavit, they had already had instances, and this was like, the best way I've heard is the analogy of building a brick wall. This was one of the blocks. So they had the suspect of drug use, they had the clear drinking and inebriation, and then they had these reports coming in of child neglect. So really all three charges were going to be that way no matter what. Now, if he had taken care of the kids and that was fine, he still could probably get, I'd have to look at the statutes, but I believe under Minnesota 152, so it was 152, what was the rest of it?
025.
Yep. 025. So you go to the actual statute, and here's the full statute. This is the whole thing. And it's even got the penalties and everything listed. So he is under section 2. So when you're looking at this, you've got section or subdivision 1. Subdivision 2 is what he falls under. And under subdivision 2, he is part 1. So if you go to subdivision 2, part 1, he is a person unlawfully possessing one or more mixtures containing controlled substances, schedule 1 through 4, does not include cannabis, or a residual amount of one or more mixtures of controlled substances contained in drug paraphernalia, which is literally what they got him for. And then here's the penalties for that. So this penalty applies to this entire statute. So he's subject to, they figured that it was more than a quarter gram, which they were right. It was almost 10 times that amount. And so he was subject to, at this time, it's a misdemeanor offense and $10,000 fine, but no more than 5 years imprisonment.
Wait a minute, that's subsection 3 that said it was repealed. That might be funny to look into if he actually qualified for that.
Yeah. And then his charges change later on, but the gun charge, and when I initially read this, I misread it, and I misread it as being so this is even further divided out. So it's statute 624.713. He is in section 1, part 10, subsection of that part 3. So when you go to that is 624.713, and you go to this law, obviously this statute's a lot longer. It's got a lot of parts, right?
Subsection. Oh wait, we already scrolled past 10 there.
So he is in, again, reading through this, he's in part 10, and so we have to go all the way down to part 10, and then you see there's 1, 2, and 3. He's actually in 3. So he is this section right here. So because he broke statute 152, he is then getting charged for having firearms in the while committing a drug crime. And that's basically what this says. And then the penalties for this is
Wait, scroll up. Penalties for sub 1 was above sub 2 there.
Yeah, there we go. That's what I was looking for. So he's subject to these penalties. Wait. Penalties for A1. Yep, here we go. Possesses, he's up to 5 years and $10,000 for that. But yeah, I learned how to read laws and statutes and all that really well. So if anybody wants to know, that's how you read all this stuff. It actually does mean something.
Honestly, they need to get better at categorizing this shit.
Oh God, yes. And then every state is different. Because I had to go through California law for shit before too.
Yeah, because that's like really confusing when you're looking at like 2 different subsections, and then you have to do like the fucking multiplication equivalent of this, like, please excuse my dear Aunt Sally, you know?
Oh, I can control F. I'm just stupid, Belinda.
I'm just saying. It would be a lot easier if they had a system set up like that.
Yeah.
Instead of this subsection A, paragraph 10, further subsection 13.
Well, and that's something that I was alluding to with case law too. That was kind of interesting. So there's that video from Legal Eagle that was based on lawyers using ChatGTP and making up fake cases. Each one of those gets filed into a book and is filed in a similar fashion.
And that ChatGTP case is pretty funny.
It is. It's actually fucking hilarious. I know you can represent yourself, but yeah.
Wouldn't it be funnier if Barnes did that for Rakietas?
Oh my god.
See, it says here
Jeez.
in the Constitution from Chat GTP, this is an 8th Amendment violation because you can mix drugs and coke, you can mix drugs and guns all you want.
Oh god, yes. Okay, yeah. And so some of that falls under different things. So like there's a couple different things to touch on what you're talking about, Belinda. So if somebody, say if you're in a vehicle stop, right, and there's drugs in the car, if somebody doesn't sit there and say, in certain states, that's my drugs, everybody in the car gets charged with the drugs. In some states, it doesn't matter if somebody fesses up or not, just because everybody's in the car, they all get charged. Same thing goes with there's a show on Netflix that was like a show about convicts and people, how they were convicted of different things and different charges. And this one guy was convicted of murder, literal murder. And no, I didn't get a chance to catch that, Ellington. I totally failed and forgot about that being today. But this one guy was convicted of murder, being no more than the wheelman for the vehicle. 2 people went in the home, killed the occupant in the home, came back out of the home, got in the car. This guy had no idea what happened. They end up catching everybody, and because he was driving the car, he got charged with the same thing as his co-conspirators. Basically, he got charged with murder and conspiracy to commit murder. Oh, sorry, Huggy. I didn't realize you were in the audience. But yeah, and then Belinda, there's some more that's going to happen here that's kind of a unique situation, which is why I've not gone off this video yet.
I'm sorry, Judge, I'm just going to interrupt. This is Katie Block, the court administrator. Do you want this next hearing to be in person or remote?
In person.
Thank you for the clarification.
Mr. Rakieta, you said contested, right?
Yes, sir.
Okay, so yes, in person. Yes.
Let's try to jump forward here because not a whole lot happens. They're just basically scheduling for the next.
And Madam Clerk, just so the court is aware, Kristen Pierce is handling this case going forward.
All right, thank you.
You're welcome.
So while we're waiting for the date, $50,000 bond, cash or surety, which means he can.
And the
pay...
matter has been assigned with Judge Fisher.
That's a stick in the side for him. So hearing that name, Judge Fisher is actually the presiding judge on his civil case as well, because again, small court, small county, rural shit. He now has the judge that he's talked shit about on stream about shooting liquor or alcohol out of her vagina and made other disparaging remarks, is now the presiding judge for his criminal case. So this guy has made a bunch of shit marks about this, and I asked initially, and actually it got answered ultimately, and all the stuff that's come out. The judge does not have to recuse herself just because he made disparaging remarks. The judge can sit there and basically give a good judgment on whether they can handle this case impartially, and if they think they can be impartial, then they can proceed with doing the court proceedings for his criminal case. So they don't have to recuse themselves. They're able to go forward. But yeah.
I mean, the only way how the judge would have to recuse themselves if they responded to whatever Nick Rakieta said about them.
Yeah. And the only other thing would be a conflict of interest they could sit there and say. But still, it wouldn't be because of any of the shit that he said. The only thing would be that I could think of would be a conflict of interest because this is the same presiding judge on his civil case versus his criminal.
Well, you know what's funny is that there was a situation like this in the OJ case.
Oh, really?
Yeah, where Mark Furman, the detective that found the glove and everything at at OJ's house and everything. Apparently, the recordings that nailed him as a racist, where he was like saying the N-word like 1,000 times and everything. Apparently, he also made comments about Judge Ito's wife, who had to sign off a document about like not having any previous like problems with certain witnesses, and Mark Furman was one of them because she had to reprimand him for misconduct in the police force.
Wow.
Yeah. So that came up, and they had to get a second hearing for where another judge had to rule on whether or not Ito could judge on like what could be permitted in the case from the recordings, knowing full well that his wife was being shit talked in there.
Oh.
So, and that went up to the Supreme Court, if I remember correctly, and it basically created like this, like another situation where not even Barnes could get to argue, like, having conflicts of interest if someone's shit talking you or a significant other in a criminal case, or if they're a witness or what have you. So
Yeah.
there's a little tie into OJ history for Nick Rakieta. Outside of like the 3 Colombian drug dealers that killed Nicole.
Oh man. And possibly prison cellmates if he does get sentenced to prison.
Yeah, because when I first heard that, and I was like, I remember watching the fucking what was it, the FX series, the trial.
Yep.
Yeah, the People versus OJ Simpson, and that came up in the show, and I looked up, did this actually happen? Turns out it did.
Huh.
So there is legal precedent that Barnes and Viva would have to fucking argue if they're going to contest whether or not Fisher would have
Yeah.
would be able to rule in this case. And it comes like from the case of the century.
That's funny. Oh man. This guy's so
although I
fucked
don't
every time something happens.
Yeah, I don't know if it's like strictly California Supreme Court or if it's the U.S. Supreme Court, which would affect all courts.
Yeah.
But it did get to a Supreme Court from what I remember.
That's interesting.
Yeah.
Okay. Yeah, Ellington, if you can get that, let me know. I'm definitely interested in that, by the way.
I'm looking at Tuesday, August 20th at 2:45.
So that's basically when his next let's call it a pre-trial hearing. It's an omnibus hearing. It's basically where they're gonna lay out all the official charges and everything against Rakieta and everything else and his co-defendants and stuff like that. So, but I don't want to ruin it too much because there's some other interesting stuff that's about to happen.
Yeah, fucking Legal Mindset said that on the casino when him and Alex Stein showed up a couple nights back.
Yeah.
So he probably knows exactly the that part of the OJ trial I was referencing there.
Huh. That's interesting.
Good for the state.
Without having a calendar sounds great.
Very well. Any other business we can conduct?
No, this. Apologies. Go ahead.
Your Honor, I have requested to see 2 of my clients and have been forbidden from doing so. I would like to see them before their arraignment.
Now, if you notice and pay attention, God of Law over here and a couple other people are perked up right now because this is an interesting prospect here. So Nick Rakieta is actually a practice licensed attorney, obviously. And then on top of that, he's now being convicted of or charged with these offenses. And he's fully right and able to represent himself, although it's highly not recommended by almost every fucking attorney. But he's taking it a step further. He's saying that basically because I am a lawyer and I have a degree in this and I am knowledgeable and I can represent others based on crimes, that I am now not just choosing to represent myself, but my co-conspirators, which is unprecedented, and I strongly believe would not have gone forward, regardless of how much Nick wants it to go forward. But I do have some interesting thoughts on what happens here.
He's going to represent his
I'm not
wife.
understanding your request. Can you repeat it?
As 2 of my clients are set for arraignment today, I have requested to see them. They have both requested to speak to their attorney, who is me, and they have been prevented from doing so up to this point. I was wondering if we could get an order to allow me to at least speak to my clients before they come into their first appearance.
Gornahachi?
Your Honor, I'm not sure if the court is aware. April Multi has been released.
Nick Rakieta wasn't aware.
And then I believe the other person he's referring to is his wife, Kayla. Is it Rakieta? Rakieta. I'll leave it to the court's discretion. They are charged as co-defendants. I believe she would have to waive any conflict, etc. But I don't take a position.
And to be frank, I don't know if that's a waivable conflict at this point, given they are co-defendants. but there's no request from the state that obviously they are married, so there's no request that they be separated. True?
Correct.
Well, it's an issue of denying counsel to Ms. Rakieta, so I will grant the request and leave that as an issue for Judge Fisher. At least to get us through the arraignment this morning.
Thank you, Your
Mr.
Honor.
Jailer, are you able to make accommodations?
Really, nothing else remarkable or eventful happens here, even when Kayla shows up later on, while looking very, 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 very much like a disheveled mess. She receives the exact same bond agreements and everything else. But it kind of became a really interesting thing there. So first off, they cannot deny Kayla her legal counsel. So that's an amendment right that they cannot violate. Then they also, by allowing them to do this, they're allowing them to do it just for the arraignment. So I didn't see it going forward to the criminal case. But it's very interesting because while they're being tried as co-defendants, I don't know if they're going to be allowed to be in the same dwelling together.
Well, I mean,
he gets 15 minutes to corroborate the story with Kayla and tell her, hey, don't let them read the charges and all this other stuff. I think it's what he was doing, basically.
well, I mean, that's the thing. It's just like he's already conspiring, and I think the judge might have fucked up there instead of letting, what is it, a public defender, take her up.
Or yeah, even any other private hired attorney.
Yeah, because the whole thing is like Nick Rakieta, he's working off of no information. He was separated for whatever reason. However, when it comes to between a husband and a wife, like even if they're co-defendants, they still can't have them testify to what was said in confidence, if I remember correctly, right?
Yeah, it
They
goes
can't.
back to I actually was watching it. It was brought up actually thoroughly recently in regards to stuff. Basically, it goes back to a biblical scripture where you're considered once you are legally married, you're considered two parts of the same person. So you cannot testify against yourself. You cannot be compelled to testify against yourself. Is why they are not allowed to testify against each other unless they choose to do so willingly. They can willingly, like Kayla could willingly say, I choose to testify against Nick Rakieta and get reduced charges, but they cannot be compelled to have her, be a witness against her will against Nick Rakieta.
Yeah, it just seems like Nick was taking control of the situation there, like he always does.
Yeah.
However, I think it was a missed opportunity, for all of this, just to keep him boxed in by the judge there.
Yeah.
During the arraignment. I mean, given the kind of shit that Rakieta's facing as a first charge, maybe the judge was taking it easy on him. But I think, if anything, it was a mercy by the judge that was allowed by court law, I suppose.
Yeah.
But I think it was a bad move altogether.
I think the only reason they did it was in the interest of allowing her to get out of jail and not have to spend the weekend over jail waiting for whatever attorney to show up, because who knows if there was a hireable attorney at that point.
Well, they technically have a few on staff at every jail, and they alternate so many days a week. That's how it is where I'm at.
Yeah, but I think even with that, you have to typically fill out a form showing that you cannot afford an attorney, and then they will say whether you can actually have a public defender and whether it'll be charged or at a reduced rate or whatever.
Yeah, that's another thing. So, again, if it's for expediency, given it's the holiday weekend, I can understand that too.
Yeah. And especially, he only had 15 minutes. I don't think he actually conspired much or had much time to conspire with her. I think realistically, all he wanted to do was go in there and say, look, this is what they're going to tell you. Do this, 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 and this. And I think that's all he was trying to honestly do.
Yeah.
But there is an interesting person on screen right now, by the way. which
Which
is
one?
uncivil law.
Oh
So-
God.
Let me ask you, Gigi,
Dude.
what's your opinion on uncivil law?
Okay. Fuck. From what I had seen, I mean, he seems like he's well-meaning. However, like given the shit that like Kino Casino and a bunch of other Kiwis have dug up, it's a bit questionable. Especially when he's eating like a fucking steak and he's talking about dating someone. And is like, "Hey, if you're in state and under in like 17, then we'll just
yeah.
talk." And I'm like, what the fuck?
Yeah, he does have a little bit of sussy behavior when it comes to that, but I learned some interesting stuff about him.
I mean, that whole Datamax shit is like the Betamax state for a dating service.
So, ironically, I don't know about the other attorneys in here, as far as like what their qualifications are, but I know he's talked about his qualifications. He's allowed to argue at the Supreme Court of the United States. Now you have to apply and be accepted to a special bar at the Supreme Court of the United States. Do you know how many attorneys presently there are in America? Let's start there. Like if you had to give a rough estimate.
Given how many attorneys there are in America,
Yeah.
how many law firms, I'd say that's a good 75 to 100,000. But for the Supreme Court, I'd say that's knocked down to a percentile. So maybe 700, 500.
So in America, there is 1.33 and change million law firms.
Okay.
So 1,300,000 and change law firms. People that can argue in front of the Supreme Court, you're right. It is a percentage of a percentile. It is 75,000 lawyers. So when I did the math, he is one of 99.96% of lawyers cannot argue in front of the Supreme Court. He is one of 0.04% of people who can. Or no, 0.06.
Okay, so
sorry.
Is Barnes one of them too?
No, not that I know of.
I mean, the way how he was like all of his cases like fucking with Wesley Snipes and Alex Jones and everything, you'd think he would be.
Which recontextualized a lot of stuff. So there's a very, very prominent scene which I'm not going to show. I don't have the ability, without going through a lot of it. I don't have I don't have a lot of time to go over just on civil law. Yeah, I seen what Jim said. Whenever the band kids are available.
On civil law and Pat Tillman teaming up.
Oh man. But no, so like when he's talking about, I've looked at this every single possible way, and I cannot refute that warrant, the warrant affidavit and everything that we just saw. That means he looked at it from being one of 0.06 people that could go to the Supreme Court and argue amendment law and all that shit. He could not figure out a way to get Nick out of that warrant. But Barnes is going to figure it out.
Well, I mean, he is a libertarian after all, and like the Supreme Court is like an unjustified court. And everything.
Yeah.
I mean, to be anything, the one court that is like still in service but has been ruled unconstitutional is the FISA court.
Yeah.
And that was the fucking court that would issue out all the fucking RICO charges for the mob and everything.
Yep. Oh man, no, it's just kind of funny. So like, I thought about it, and aside from I mean, think about that. There's only 75,000 people that could really argue this case up to the level that Barnes is even implicating they could argue to. And Barnes, as far as I know, is not one of them. He says he's a constitutional lawyer, but constitutional law does not mean you can argue in front of the Supreme Court. So when I looked up his website, he says that he's a financial lawyer, criminal, civil, and constitutional law were his main practice fields. So it's just, I thought it was funny. So like, a lot of people were shitting on Kurt, and mind you, there's things to shit on Kurt about. Kurt's a potato of a human being, okay? But I don't think that his ability to argue law at the level that he's able to argue at should be shit on. I think like when he was looking at things, and I think that's where a lot of people are applying morals to a lot of people that are not necessarily immoral, but are not going to argue morals ever. They're going to argue
We have to. We have to law max our Constitution.
Dude,
Oh
that's
boy.
fucking good.
Law maxing within civil law. Oh my god.
Yeah, if you're in the same state, I'm gonna need you to age max.
Age max. It's like you need to be 17, but like a day away from 18 max.
Not this freshly shit. None of this freshly shit at all. I don't need freshly 17. I need nearly ripe 18.
Oh man.
Oh fuck.
I mean, I feel bad for the fucker. Like, I mean, come on. Your friend is being charged with all this shit, and you know, without a shadow of a doubt, he's fucked.
Yeah.
Like,
yeah. And that's why I think like
You
he
are-
actually got like upset is like I think he was more upset not necessarily at the morality of the situation or that Nick's fucked. I don't think he necessarily cared that Nick was fucked, I'll be honest. I think he was more upset with I haven't figured out a way to argue this. Like even me,
Well, I mean-
someone who knows the law inside and out, cannot argue this.
Yeah, I mean, that's like being in a fucking corner of a dark room, kind of like, you know, just not knowing what the fuck's going on.
Yeah. Jesus. Oh, Belinda, you missed all the good stuff with DBDR. I'll have to get you exposed to DBDR at some point. I know you've seen a little with Huggy, but we've extensively covered and argued with the guy on my stream. But yeah,
You know,
really,
we should probably get Pat Tillman on. That'd be fun.
He'd sit there and look at this arraignment and go brutal. You know, if you had just gone to the club with the band kids and popped a couple twisted
why
teas,
didn't
you
you-
would not be in this position.
Yeah, Nick, why didn't you go there instead?
Oh fuck.
It's like not even DBDR turned to fucking coke. He went to Twisted Tea and like strippers.